Hello, and welcome to my presentation on the reform of severance in joint tenancy. My name is Alfred Nyangu, and my student ID is 1352132. In this presentation, I will explore two areas of co-ownership, which are the joint tenancy right of survivorship and the idea of severance, which is the conversion of a joint tenancy into a tenancy in common. The methods of severance of personality were classically described by Pagewood VC in 1861 in the Williams versus Hensman case, and those methods still survive today. And although the Law of Property Act 1925 imaginatively reformed the law of co-ownership, it did not alter pre-existing methods of severance. Instead, it confined severance to beneficial joint tenancy, and in addition, provided that a joint interest in land could be severed by notice in writing given by one joint tenant to the others. This statutory provision is now nearly 100 years old and dates back to a time when co-ownership was comparatively rare and would generally have arisen in connection with devolution of property by will. Today, with the increasing popularity of co-ownership, and in particular joint tenancy, the law relating to severance directly affects the ownership of many homes. In this presentation, I will briefly consider three options for reform of severance, which usually raise issues and, as aforementioned, affect many homes. These methods are the incorporations of all methods of severance into a clear statutory provision, the restriction of methods of severance to written notice, the introduction of severance by will. The first suggestion is obviously limited in scope, but the other two suggestions are both radical and controversial, and the purpose of this presentation is to propose, analyze, and evaluate how severance may usefully be reformed. With regards to the incorporation of all methods into clear statutory provision, presently Section 36 subsection 2 of the Law of Property Act 1925 is rather evasive in its approach. It specifically retains the right to sever a joint tenancy in an equitable interest, then further goes on to say, quote unquote, provided that where a legal estate, not being settled land, is vested in joint tenants beneficially, and any tenant desires to sever the joint tenancy in equity, he shall give to the other joint tenants a notice in writing of such desire, or do so such other acts or things as would, in the case of personal estate, have been effectual to sever the joint tenancy. End quote. On this provision, one's first comment would be to say that it is unnecessarily mystifying due to the pressing problem of vagueness that lies within Section 36 subsection 2 concerning the provision when written notice takes place. The difficulty lies in the words, provided that where a legal estate, not being settled land, is vested in joint tenants beneficially, end quote. A literal interpretation of this phrase suggests that the subsequent provisions apply only where there is a legal estate, and where the legal estate is held conterminously with the beneficial interest. This means where the joint tenants at law are the same persons as the joint tenants in equity. If indeed such are the restrictions, their purpose seems unclear. Thus, any redrafting of the sections, we hope, may clearly provide that all methods of severance are freely available to any joint tenants of an equitable interest in land or of personalty. The second proposal by the Law Commission is the restriction of methods of severance strictly to written notice. Should it be too problematic to include the Williams versus Hensman case requirements into statute? The three common law categories demonstrated by Williams versus Hensman raise problems such as determining what exactly is a sufficient act. It seems as though the issuance of a writ for sale of land is a sufficient severing act, as seen in the Reed-Draper's case, while physically demarcating a property, as seen in Greenfield versus Greenfield, is not. This is evidence of the uncertainty of the severance category of an act of operating upon one's own share, as this is understood to refer to an act which destroys the substantive identity of joint tenancy or destroys one of their unities. Now, let us pause for a second. Should the demarcation of land in a joint tenancy and thereby restricting one another of occupation of the rest of the property amount to possession of the unity of possession? If you think this act destroys the unity of possession, then why would the judges in Greenfield suggest otherwise? Moving on, under the method of acting upon one's own share, the sale or mortgage of a beneficial interest severs, both of which would involve writing of some sort to be carried out. Thus, it seems clear that the mere amalgamation of this category of severance into written notice wouldn't restrict it in essence, but just set it out in clear plain text. The anomaly of section 36 subsection 2, in its suggestion of an apparent limitation of severance by written notice to cases where there was a legal estate, led to Lord Denning's emphasis on the use of the word quote unquote other end quote in the phrase to do such other acts in the famous case of Bridges versus Rawnsley. It is clear that the word other is an ambiguous term that has only brought about an unclear position in this country. In Australia, however, the Australian High Court has declined to follow Bridges versus Rawnsley in this respect. The other common law methods of severance are by mutual agreement and by a mutual course of conduct. Mutual agreement does not cause too many problems, although it is unclear whether or not an oral agreement to sever would now be effective due to the introduction of the Law of Property Miscellaneous Provisions Act 1989. As you can see from the last bullet point in this slide, it appears that this would not be possible. The last and most elusive of the three common law categories of severance is severance by course of mutual conduct. There exists an arsenal of mutual conduct cases in which a mutual course of dealing has been unsuccessfully urged by the appellant. With regards to this category, there is a list of scenarios of mutual dealing which have not amounted to severance, and some of these are the inclusion of jointly owned property in accounts as a partnership asset, as seen in Barton versus Morris, the splitting of a house in two separate maisonettes for separate occupations, as seen in Greenfield versus Greenfield, and discussions concerning the sale of the jointly owned former matrimonial home and the diversion of proceeds of sale in the context of divorce proceedings, as seen in McDowell versus Hirschfield, Lipson and Romney and Smith. One can deduce from the analysis of these cases that it seems easier to explain what does not amount to mutual conduct rather than what does. Nevertheless, Judge Blackett Ord in Gore and Snell versus Carpenter explained severance by mutual conduct as occurring, quote unquote, where over the years the parties have dealt with their interests in the property on the footing that they are interests in common and are not joint, quote, end quote, as was the case in Wilson versus Bell. However, as the case of Wilson versus Bell is an old case, the lack of a more recent case where severance has been found on the category of mutual conduct raises serious concerns. That said, the next thing to have a consider will be the effects of such restrictions to written notice. The reform of acting upon one's own share has attracted criticism by Louise T., an accredited scholar, with her stating abolition of the informal method of acting upon one's own share would prevent a joint tenant from dealing with his equitable interest in any way which would in turn render voluntary alienation, whether by sale or mortgage, impossible unless there had been prior severance. This would also affect involuntary alienation such as bankruptcy. Thus, we can infer from this analogy that an absolute restriction of severance to written notice could just further complicate an already complex field of the law, as well as raise unfairness to creditors of bankrupt beneficial joint tenants. Nevertheless, the abolishing of severance by mutual agreement and mutual conduct could have fewer legal repercussions, and this can be seen by the amount of times severance has been found on such grounds in the last 70 years, which is minimal. Abolishing these two informal categories would bring about much sought after certainty and would not bring about crucial limitations. That said, in considering abolition of informal methods of severance, the advantage of permitting informal methods in terms of fairness to the layman must be weighed against the disadvantage of the uncertainty engendered by the possibility of informal severance having taken place. The other proposed reform method by the Law Commission is the introduction of severance by will. This is a rather radical suggestion that has been examined by various scholars in the past, and one that counters the whole concept of survivorship right of joint tenancy. This survivorship right is strongly grounded in British history. An introduction of severance by will would in essence be abolishing the right of survivorship. Arguments for this method have suggested that the wife in the matrimonial home would endorse severance by will for circumstances in which there is a breakdown in the marriage and the spouse may be anxious to sever but does not do so because of fear of aggravating negotiations over child custody, for example. More in support of this method have suggested severance by will would prevent undesired devolution of property. There are two arguments against severance by will, and the first is that it would be unfair to allow severance by will due to the possibility of a rogue beneficial tenant secretly severing by will and then enjoying the possibility of the right of survivorship without any risk to his or her estate, which would allow for such a tenant to have his cake and eat it. The second difficulty would arise in construction because currently we already have a situation where it is sometimes uncertain whether inter vivos severance has taken place. The additional possibility of severance by will would no doubt compound this problem and result in more uncertainty for the survivors. The question to be asked is whether or not the problem of undesired devolutions is sufficiently serious enough to justify a reform which would subsequently produce problems both of principle and practice. The answer to that question seems to be that the problem of undesired devolution is not as serious as the repercussions this introduction would bring. That brings me to the final part of my presentation, which is the author's proposal and conclusion. After this analysis, it can be deduced that it would be best to abstain from adhering to the radical proposals of abolition of informal methods and introduction of severance by will, and would be greater suitable for me to suggest a more conservative approach for reform to endorse. This can be achieved by taking into consideration all the aforementioned proposed reforms and designing a final proposal by combining all these reforms and negating the most radical of these. Thus, the proposal would be to abolish the method of severance by mutual conduct and clearly include mutual agreement and way of acting upon one's own share into Section 36 of the Law of Property Act, as well as rewording the section to confirm that severance by written notice is available all the time, whether legal title exists or not. This would effectively combine the proposal of incorporating all methods into a clear statute and instead of restricting severance to writing, abolishing the informal method of mutual conduct. Severance by will would bring about more injustice and unfairness than any positive gain to land law. Thus, incorporation of severance by will would be unconscionable and would be more advantageous to law if it was not considered at all. I must reiterate that the proposal would be to abolish the method of severance by mutual conduct and clearly include mutual agreement and way of acting upon one's own share into Section 36 of the Law of Property Act, as well as rewording the section to confirm that severance by written notice is available either to the legal title owner or the beneficial interest owner of the joint tenancy. Thank you very much.